Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
And now, the Federal Drive with Terry Gerton, sponsored by GEHA.
Welcome to the Federal Drive on Federal News Network. It's Monday, December 15th. I'm your host, Terry Gerton, and I am glad you're here. Coming up on this hour of the Federal Drive, a new bill could turn military experience into energy sector strength. Plus, a final regulation issued on Halloween has reshaped the public student loan forgiveness program. Those stories and much more ahead during this hour of the Federal Drive. We begin with this. The Trump administration's deferred resignation program this year led to more than 150,000 employees leaving their jobs in exchange for months of paid leave. But for many of those who took the DRP, the offer came with an added opportunity. Thousands also qualified for early retirement. Federal News Network's Drew Friedman spent the last several months conducting interviews, reviewing documents, and gathering data about federal retirement processing. She found that the DRP helped lead to a massive and unexpected surge in applications, now inundating the government's retirement systems.
Though many had not planned to, thousands ended up applying for retirement this spring as part of the Deferred Resignation Program, or DRP. Now, months later, that flood of applications has overwhelmed retirement processing across government. Many who took the DRP and separated in September are still waiting on their annuities right now, as agencies' HR offices try to manage unusually high application volumes. Rob Shriver, a former acting director at the Office of Personnel Management, summed up the experience as one of incredible frustration.
Agency HR officials play a critical role in processing individual employee retirement applications, making sure the employee has all of the right documentation, in addition to the huge volume of other workforce-related matters that have been initiated by this workforce. HR was already understaffed. Lots of HR people have now left, and they have an ever-increasing workload. So it's all piling up. It's all going to create backlogs.
But as both OPM and agencies work through that flood of applications, they're also anticipating a second wave of retirements later this month. Due to the DRP, OPM is already well above its typical retirement workload and seeing processing times continually slow down as a result. With retirement applications on track to surpass 140,000 this calendar year, OPM is facing the highest retirement volume in at least the last quarter century, possibly ever. But as that all comes to pass, OPM has also been working to modernize the paper-based retirement process with a new platform called the Online Retirement Application, or ORA. That effort, while long awaited for many, is also leading to some further questions.
There's some uncharted waters here.
Tiago Glieger is a federal retirement planning expert with RMG Advisors. He says the converging changes are exacerbating an already difficult situation.
OPM has not really handled A, this new system before, and B, this many federal employees retiring all at the same time. You have to remember, what's different here is now HR is swamped. There's tons of people retiring. There's less of them around to be able to do this, which is causing some of the bottleneck.
But according to OPM, having the ORA platform available this year has been crucial for managing both current and upcoming waves of retirement applications.
A surge like this would be extremely difficult for our legacy processing to work. It just wasn't built for something like this.
Kimya Lee is OPM's Deputy Associate Director for Retirement Services.
Despite record high retirement volumes this year, ORA is performing well in production. This gives us confidence as we prepare to continue to increase the retirement activities in 2025 and into 2026.
Still, many retiring through the DRP are reporting delays and frustrations as they wait for their annuities to get finalized. Federal News Network interviewed more than a dozen retiring employees, all at various points in the process and across several agencies. Most of the retiring employees that we spoke to, understandably, didn't want us to use their names. We've used some AI-generated voices to convey what they told us. Some say they're seeing errors on their applications, showing up in calculations for service history, high threes, and in some cases, missing documents.
I've been yanked around. The left hand didn't know what the right was doing.
Others say they're frustrated as they remain stuck in what they call administrative limbo, with little communication from HR offices and few answers.
It just felt like I was out on an island.
And some have yet to receive their annual leave payouts, something that usually tides over retirees financially until they can get an interim annuity.
We are literally stuck in limbo. No payments, no more checks. This is causing financial hardship for so many people.
Regardless of the situation, many still expressed appreciation for the HR specialists, who they say are doing their best given a difficult situation.
My heart is with the HR offices. They are overworked, underappreciated, and this is really the biggest test they've ever faced.
And as those retirees continue to wait, the typical end-of-year retirement flood that OPM is expecting will add to the workload, and as a result, likely lead to further delays in the processing timeline.
We're going to continue to just try to be as transparent as possible with people and, recognize that, look, this is, a very, very significant number of applications we're seeing.
Scott Cooper is director of OPM. He says the agency is adding overtime hours and temporarily staffing up in retirement services to deal with the flood. They're also trying to focus on delivering interim annuities to retirees as quickly as possible.
We're trying to get ahead of that and make sure that we can, be as responsive and make sure that we're attentive to the fact that we want to minimize the time it takes for somebody to be able to get, at a minimum, the interim payment so that they don't have any material interruption between, cash flow for themselves.
Despite OPM's efforts, some say the Trump administration's workforce disruptions across the entire year have ultimately heightened employees' uncertainty. At the National Active and Retired Federal Employees Association, or NARF, John Hatton has been tracking the workforce changes this year and hearing firsthand how that's impacting those who are trying to retire right now.
All the different disruptions from the administration, whether it's the shutdown, whether it's reductions in force, hollowing out agencies, hollowing out HR staff through a deferred resignation program, that all could have a disruption on getting these files processed and over. That adds a little uncertainty in the process. Maybe they have plans for getting this done and getting it over, but certainly until it's done and files are transferred and everything's over to OPM, we're concerned that the agency side of the process is going to be difficult.
But in the short term, there's not a whole lot that retiring employees can do outside of simply being prepared for things to take much longer than usual. That's according to Tammy Flanagan, a retirement advisor at Retire Federal.
I would tell them just to keep watching, watch their mail for any communications from OPM, watch their bank account, because sometimes the money goes in the bank and you don't get a communication, you just see it show up. Be prepared that it may take longer because of the volume and the fact that, we've got all this new system with the ORA to implement. But I don't know what else they can do. I really don't.
Drew Friedman, Federal News Network.
You can find many more details in Drew's special report at federalnewsnetwork.com. And be sure to tune in tomorrow morning for part 2 of this story. Up next, a final regulation issued on Halloween has reshaped the public student loan forgiveness program. This is the Federal Drive with Terry Gerton on Federal News Network. Welcome back to the Federal Drive with Terry Gerton on Federal News Network. The Department of Education has finalized regulations that redefine public student loan forgiveness eligibility, barring organizations with a substantial illegal purpose. Randall Thomas, partner at Morgan, Lewis & Bacchius, explains what this means for borrowers, employers, and compliance going forward. Mr. Thomas, thank you for joining me.
Thanks so much for having me, Terry.
It turns out that not everything was shut down during the shutdown. The Department of Education issued a final regulation on Halloween that picked up on a March 7th executive order related to the Public Service Loan Forgiveness Program. Tell us about what this new regulation does.
That's right, Terry. The regulations finalized proposed regulations that were issued in August and that implement that executive order. And that executive order directed education to propose revisions to the PSLF regulations to ensure the definition of public service excludes organizations that engage in activities that have a substantial illegal purpose. That executive order stated that it was the policy of the administration that individuals employed by organizations whose activities have a substantial legal purpose shall not be eligible for the PSLF program. Education amended the regulations to provide that a qualifying employer for purposes of the program does not include organizations that engage in these specific enumerated activities in the regulations such that they have a substantial illegal purpose. Qualifying employers for people who are familiar with the program or those who aren't generally include federal, state, local government agencies, Section 501c3 organizations, and certain other entities. And these regulations were issued after the statute, the PSLF statute was enacted in 2007 and first became effective in 2009. And those regulations have been amended 7 times since they were first promulgated. The new regulations establish that to be considered a qualifying employer, an organization must not engage in an illegal activity such that it has substantial illegal purpose. And with that language and that standard, education is effectively adopting the IRS's illegality doctrine in these regulations. Education states that the IRS's use of the doctrine is a basis for education to issue the regulations. Education also listed several activities deemed to reflect a substantial legal purpose, which we'll probably cover in a few minutes. And the proposed regulations received nearly 14,000 comments and were generally finalized without substantive changes.
I think most people would agree that agencies that are engaging in illegal behavior ought not to be subject to loan forgiveness. What is new about this regulation, especially when it comes to defining the illegal activities?
Yeah, so historically, like we mentioned just a minute ago, Terry, this was a status test and not a conduct test by the Department of Education. You could look to a Section 501c3 organization and see that the IRS had made a determination with respect to that exempt status. And the IRS separately employs an illegality doctrine, but now the Department of Education has said that it will also apply the illegality doctrine based on a preponderance of the evidence to determine whether an organization is operating for a substantial illegal purpose. And here they define certain illegal activities as indicative of having a substantial illegal purpose. Those activities were also all noted in the executive order from March of this year, and they include aiding or abetting violations of federal immigration laws, supporting terrorism, the use of puberty blockers or sex hormones for minors in violation of federal or state law, engaging in the trafficking of children to another state for purposes of emancipation from their lawful parents in violation of federal or state law, engaging in a pattern of aiding and abetting illegal discrimination, and engaging in a pattern of violating state laws, which is defined as a final, non-default judgment by a state court of trespassing, disorderly conduct, public nuisance, vandalism, or obstruction of highways.
Well, those are pretty specific. How will the Department of Education actually determine if an agency or an organization engages in those activities? What will they look at?
So the employer disqualification process here requires education to find that an employer has a substantial legal purpose by a preponderance of the evidence after weighing the employer's illegal conduct and narrowly focusing on only the illegal conduct enumerated in the regulation. The preamble to the regulation notes that a determination by education regarding illegality only represents education's conclusion that the organization is not a qualifying employer and does not represent a determination by the IRS regarding tax-exempt status. Education will determine that a qualifying employer violated the applicable standard when it receives an application in which the employer fails to certify that it did not participate in activities that have a substantial legal purpose, or when it otherwise determines that a qualifying employer engaged in these activities unless education approves a corrective plan signed by the employer. There's an employer reconsideration process that gives employers the right to submit additional information and seek review of determinations. That process is aimed at providing due process to ensure that education considers all relevant information prior to taking action to remove eligibility and to ensure that employers will be given an opportunity to respond except in cases where there's conclusive evidence that the employer engages in activities such that it has an illegal purpose, substantial legal purpose rather. And the education presumes that the following evidence is conclusive. That includes a final judgment by a state or federal court whereby the employer is found to have engaged in illegal activities such that it has a substantial legal purpose, a plea of guilty or no contest whereby the employer admits to having engaged in illegal activities that have a substantial legal purpose, or pleads no contest to allegations that it engaged in illegal activities with a substantial legal purpose, or a settlement that includes admission by the employer that engaged in illegal activities that have a substantial legal purpose. It provides that nothing in the determination process shall be construed to authorize education to determine an employer has a substantial illegal purpose based upon the employer or its employees exercising their First Amendment rights or any other rights protected under the Constitution. And education notes that even without such explicit references, the regulation could not be enforced in a manner that contravenes the First Amendment, and that lawful activity will not disqualify an organization, no matter how controversial or unpopular it may be.
I'm speaking with Randall Thomas. He's a partner at Morgan, Lewis & Bacchius. All right, that's a lot of legal speak about the requirements. What, if any, new responsibilities or risks does this create for the public service organizations who might have borrowers participating in the program?
Yeah, so two impacts here, the qualifying employers and also the borrowers. Of course, the employers now bear the responsibility of affirmatively certifying that they are not engaged in activities with a substantial legal purpose. They face disqualification now based on this new preponderance of the evidence standard, and certain things like judgments, no contest pleas, and settlements are treated as conclusive evidence that the employer engages in activities such that it has a substantial illegal purpose. Employers will want to engage counsel to think about how the PSLF regulations may apply and whether the employer's activities expose it to any PSLF disqualification risk under the new regulations. And they'll probably want to do that with an eye toward these activities that the regulations say are indicative of a substantial legal purpose. There's also the borrower impact, and thankfully these regulations don't have an effective date until July 1st, 2026. So you do have some runway to figure out how they're going to apply to your employer. For borrowers, the regulations will remove PSLF eligibility for individual borrowers during periods of employment by organizations that have been disqualified. Where an employer is deemed to have engaged in activities that breach federal or state law, affected borrowers won't receive credit toward loan forgiveness for months worked after the determination date of ineligibility, but borrowers will receive full credit for work performed until the effective date of education's determination that the employer no longer qualifies. And under the regulations, education is required to notify borrowers of a qualifying employer status if the qualifying employer is at risk of becoming or becomes ineligible to participate in a PSLF program. Borrower cannot request reconsideration of a determination by education that resulted in the employer losing status because the employer has a substantial legal purpose.
Are any of these new regulations being tested in legal cases?
There are. Several cases have been filed so far challenging the regulation.
And what is the status of any of those? Can you derive any sense of where this might go in the future?
I can't opine right now. I don't think that I think that it's too premature. I think these regulations were just finalized a little bit over 3 weeks ago, and I don't know that there's been any action on these cases.
What do you think this signals for the future, then, of the Public Service Loan Forgiveness Program? Do you think the authorities will continue to be tightened and the eligibility requirements strengthened?
Yeah, Terry, I have no expectation about whether they will or won't be tightened any further, but the new rule is clearly designed to tighten PSLF standards, and the administration, through the executive order and education and the preamble to the regulations, they say as much. The preamble to the regulation discusses at length the aim of the regulation in ensuring that taxpayer dollars are not misused and strengthening accountability and enhancing program integrity. The preamble states that the regulations will protect hardworking taxpayers from shouldering the cost of improper subsidies granted employees of organizations that undermine national security, and I'm quoting the regulation here, and American values through criminal activity. I can't speak to the policy or the balance between accountability and access to forgiveness. I will note that the education notes in the preamble to the regulation that it disagrees with assertion that the rule will have a significant macroeconomic effect on labor markets in education, healthcare, social services. They stated that they found no basis to conclude widespread effects would be likely, and that they expected most organizations to voluntarily comply with the rule, such that education anticipates that it will take action to remove eligibility for less than 10 organizations per year.
I've been speaking with Randall Thomas. He's a partner at Morgan, Lewis & Bockius. I really appreciate you bringing this regulation to our attention and helping us understand it.
Of course. Happy to help, and thank you for having me, Terry.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Listen to the Federal Drive on your schedule. Subscribe wherever you get your podcasts. Still to come, defense, healthcare, oversight, and spending. These four fronts are exposing deep divides on Capitol Hill. But first, a new bill could turn military experience into energy sector strength. You're listening to the Federal Drive with Terry Gerton on Federal News Network. Welcome back to the Federal Drive with Terry Gerton on Federal News Network. The electro-manufacturing industry powers everything from national security to AI leadership, but a shortage of skilled workers threatens progress. The National Electrical Manufacturers Association sees veterans as the solution and backs the Veterans Energy Transition Act to make it happen. We'll explore the stakes and the bill with Peter Farrell, Senior Director of Government Relations at NEMA. Peter, thank you for joining me.
Glad to be here. Thanks for having me.
You are involved with the National Electrical Manufacturers Association. We have heard a lot of talk about underemployment in the trades, the skilled trades, but NEMA makes the point that this kind of security, electrical security, is like national security. Walk us through that argument, and then we'll talk about your specific programs.
NEMA, well, first let me introduce what NEMA is to your members. The Electrical Manufacturers Association represents about 300 or so companies, both large and small, that produce the equipment and components that go into many of other sectors throughout the economy, which include the energy sector, the defense industrial base, the water sector, and others. Sectors that are really kind of, on their own are important, but holistically really kind of make not just the economy function, but also our nation function holistically. And so our members from the grid side and the energy side make the components and the equipment that not only that power communities, that power warehouses, that power manufacturing facilities, but they also power defense applications from military bases, and also provide the equipment for industrial military sector as well. So, without those components, really there comes a gap for defense purposes and for energy purposes. And those two things, of course, are very interrelated. And so NEMA helps provide, fill that gap with our manufacturers and the components and products they provide.
What are the specific workforce challenges that you're facing in the electrical manufacturing field?
So NEMA conducted a grid reliability study that was published at the start of this year. And it concluded that there were three main buckets of areas that were really driving energy demand. And this ties into your question, but for some context, with the growth of energy needs for remanufacturing purposes, for electrification purposes, for EV purposes, but also for AI and data center purposes, there is this new demand for all of these products all of a sudden. And so, to make those components, to make all of those things possible requires a very diverse and pretty skill-heavy workforce. And those skills, and from a manufacturing perspective too, I want to just kind of emphasize, it's not just skills that involve folks' hands in a factory, kind of that traditional old school way of looking at a manufacturing. A lot of manufacturing is automated. A lot of it's connected systems. A lot of it is that require new age skills in terms of how do we scale manufacturing. And so the workforce needs in this area are very wide and very deep. And so we need folks that know how to wind coil, that can stack cores made out of electrical steel to make distribution transformers. They're very kind of classic and traditional hands-on work. But we need folks that understand how to manage and operate industrial control systems, operational technologies, IT specialists, welders, and other kind of more skilled new age jobs. All of those things together come together to form really what the modern manufacturing environment looks like. And so all of those jobs are very specialized and very unique, but really it's kind of an all of the above when it comes to the skill sets.
And NEMA's making the case that transitioning service members and veterans are an optimal target pool for you. Tell us about why you think that and what you're doing to recruit them.
So right now, NEMA is looking toward kind of implementing a program pursuing a piece of legislation called the Veterans Energy Transition Act, or the VETS Act. And what it is that it's a piece of legislation, a bipartisan piece of legislation that was introduced earlier this year by Representatives Jen Kiggins and Chrissy Houlihan, both who are veterans themselves. And what it seeks to do is to really kind of bring the supply chain components of the energy supply chain to meet the workforce that veterans provide, or that can provide. And so veterans have a lot of skills that they learn throughout their careers, especially lengthy careers if they've been in for many decades. And so it's a way of trying to, seamlessly as possible, take the skill sets, whatever they may be, whether it's in management, whether it's in operations, whether it's in logistics, and just to name a few, and to bring those skills over to the energy sector to help meet the moment and fill the voids in those jobs in those many areas that I mentioned just a second ago. And so this is done. We feel that veterans, of course, kind of play an important role and kind of have a really special element that they bring. They're mission driven, they're team driven. They look at things holistically, but also, in how they apply their skill sets. All of these things matter. And so for us, those kind of intangibles that kind of the military provides and, develops and really instills, and not just workforce and values and things of that nature, but also in terms of how military service folks just view work and kind of the meaning of work and why it's important. We feel like that's a very valuable intangible that, when applied to the energy sector and to manufacturing, can really produce tremendous benefits, not just for the companies that hire them, but also for the communities that they'll end up serving through the course of their work.
I'm speaking with Peter Farrell. He's Senior Director of Government Relations at the National Electrical Manufacturers Association. We'll come back to the legislation in a minute, but there are already a number of programs out there that have been put in place over the last couple of decades to support transitioning service members. There's apprenticeships with unions in the industry you're speaking of, right? Electrical apprenticeships and some of those. There's Skill Bridge. There's transition programs from the veteran serving organizations and fellowships. Is NEMA engaged with those? And if you are they not working for you? Is that why you need legislation that proposes a new solution?
One of the organizations that NEMA is involved with is the Veterans Internship Providing Employment Readiness Program, or the VIPER program. And what that does, that program is focused mainly on trying to reduce suicides of folks that leave the military and then find themselves without the ability to kind of have any meaning in their life. And so really that program is meant to help marry up companies and folks who can employ veterans with those folks with those skill sets. So it's a very complementary kind of program to what the legislation is trying to do. But the legislation is proposed based on the folks at the Niskanen Center, which is a think tank here in Washington, D.C., identified not only that there was a workforce shortage to provide jobs in the energy sector, but that veterans provided really kind of this complementary tool for it. But as you point out in your question, that there are many existing programs to help veterans prepare for the workforce. There's the other side of that coin, which is how is it that we're preparing companies to meet that workforce as they depart the service, or to help veterans who have already departed, or actually involve spouses in a way. And so what this does is it's an attempt to kind of incentivize and help companies meet veterans or transitioning folks where they are. Because it's one thing to say, a program has helped someone who's transitioning out learn how to build their resume, learn how to dress, learn how to conduct an interview, and then go to a job fair. But the question is, well, are the right jobs at that job fair? Where have they been incentivized? Are they able to participate in those opportunities to meet those veterans? And so this bill would help kind of give the resources to especially small and medium-sized manufacturers that make the right components and make the right pieces of equipment, but they just don't have the budgets or the resources to really reach out to those members. This is really kind of, in a sense, helping, like I said, the other side of that coin, to help companies meet veterans where they are, and so to, in a sense, complement kind of the existing veterans transition programs like SkillBridge, like TAP, like Solid Start that are already on the books.
In the interim, then, while you're working on the legislation with members of Congress, what do you want employers in this sector to know, and what do you want transitioning service members and veterans to know? How can we bring them together while we're waiting on the legislation?
Well, again, there's programs like the VIPER program, and to really kind of bang the drum around these issues and, through, great avenues through your program, for example, to let folks know that these things exist. I think in some ways with, there's a lot of information out there, and for a lot of folks, it's confusing. What do you listen to? Who are the best resources to rely on? And so really kind of emphasizing to not just employers, not just to manufacturers, but also to folks that do distribution and folks that are in the contracting world that, there are a lot of companies that need this employment, that they're good jobs, that they are, a lot of here in many ways, it's the most American of things. It's an American, job that you're getting. And that they provide very well. But there's a need. And sometimes it's a lack of just not knowing that these needs are out there. And so in the interim, getting the word out around the fact that the industry as a whole, from when a component is made to how it gets delivered to how it gets installed, all of those sectors need workers. And so, but also that, there's 200,000 or so veterans that are leaving the service, retire for one reason or another about every single year. But, according to statistics from Viper, only about a quarter of those folks have jobs immediately after they leave the service. And so it's how do we ensure that folks are aware that there are willing participants that want to utilize the skills that have been developed over many years of service, and to build upon those skills to, help veterans or folks know that there is a place for a lot of those folks, but making sure that they marry up and that they can one knows about the other, and it's and making sure that communication is out there.
I've been speaking with Peter Farrell. He's Senior Director of Government Relations at the National Electrical Manufacturers Association. Thanks so much for sharing the opportunity with us today.
Appreciate it. Thank you so much.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts. Coming up next, defense, healthcare, oversight, and spending. Those four fronts are exposing deep divides on Capitol Hill. This is the Federal Drive with Terry Gerton on Federal News Network. Welcome back to the Federal Drive with Terry Gerton on Federal News Network. From the NDAA fight over helicopter flights near Reagan National to stalled healthcare extensions, unfinished oversight on a deadly boat strike, and 9 spending bills still hanging in the balance, Congress is juggling high-stakes battles with no easy compromises. Mitchell Miller, Capitol Hill correspondent for WTOP, is here with the fault lines shaping the final stretch of the year. Mitchell, thanks for joining me.
You bet.
Hottest topic, I think, is the NDAA on the Hill. It passed the House. What's going on next?
Well, it's going to the Senate, and there are a few little tripwires in the overall more than 3,000-page bill, but I think it is on its way to getting passed. This is something, as you well know, that is always passed every year for more than 6 decades, which is pretty rare in this sharply divided Congress. So there's, a lot of support for it broadly. I think, obviously, the 3.8% pay increase for military personnel, a lot of talk among the leadership related to acquisition and the reforms that are taking place related to that a lot of these weapon systems, basically there's a concern among lawmakers that the Pentagon can't, obviously, the metaphor is you can't turn around an aircraft carrier very quickly. And similarly with acquisition, you can't just adjust something super fast. But they have put in a lot of reforms that the lawmakers at least believe will allow the Pentagon to quickly react and create new weapon systems on a faster glide path than they currently are now.
As people have been making their way through the 3,000 pages in the conference bill, there's been some surprise about provisions that folks thought were home runs and got dropped as the bill went through conference.
Right, and one of them is the right to repair provision, which, of course, would allow people to basically, within units of the Defense Department, to fix their own equipment, which sounds pretty basic, but it would provide a lot of additional resources to do that. And everybody thought that was going to go through pretty easily, but for whatever reason, it was pulled. And I think that has sent some shockwaves through the contracting world as to why that is going to happen. I think that as as we move into the next year, we will probably see that looked at again. Certainly some things have been pulled or changed over the course of this whole NDAA process. And one of the side notes that came up this past week was the fact that they would basically allow for the Army to continue its helicopter flights near Reagan National Airport as they used to. They, of course, have been limited since that accident, terrible accident in January that killed 67 people in a midair collision involving an Army helicopter and a commercial jetliner. And there was a lot of furor last week among lawmakers related to including this language that essentially says that the Army gets a buy on putting in the new communications systems that would allow for helicopters to be quickly identified, more quickly identified than on radar, and that they could essentially potentially go back to the status quo. So I talked to Virginia Senator Mark Warner, and he says he's going to reach out to the Pentagon to try to see if they can get that changed. But I don't think these issues will jeopardize the overall NDAA. I think we can see that it will be passed this week.
Well, that will be progress, at least to have one of those bills through, even with some of these outstanding issues. The other funding issue that's certainly top of mind is whether or not we're going to get a repeal on the ACA extensions. It failed in the Senate. Where does it go next?
Well, this is really interesting because during the whole debate over the government shutdown, they said, we have plenty of time. We can deal with this later. It doesn't happen until the end of the year. The subsidies going away from the ACA. Well, here we are. And we have not really gotten through any kind of progress. The Senate, as you mentioned, voted down two proposals, dueling proposals. One, the Democrats wanted to extend the ACA subsidies for 3 years. The Republicans came up with an alternative plan related to health savings accounts, which they say would provide more control for Americans over their own health care costs. And variations of those two themes are now being sorted out in the House. A lot of House moderates on the Republican side, frankly, are concerned that it's going to look bad politically heading into the midterms if they don't do anything related to this issue. So you have a really unique situation where this is such a big issue that you have people trying to essentially do an end run with discharge petitions in the House for the Republican leadership. Various proposals extending the ACA possibly 2 years with caps on how much people can make, various requirements related to cutting out fraud. So it's going to be fascinating to see how all this unravels this week in the House. My personal thinking is that they are not going to get anything actually passed this week. And then we are going to, of course, head into the new year where you're going to have more than 20 million people under those ACA provisions who will be seeing those soaring costs related to their health care premiums. So it's pretty fascinating that Congress just was not able to do this, at least to this point.
Mitchell Miller is Capitol Hill correspondent for WTOP. Mitchell, around that ACA issue, there was so much bad blood and mistrust throughout the shutdown. How is that impacting what's got to happen next, which is appropriations bills?
It's really left a bad feeling on both sides, I think. And unfortunately, that has impacted this whole appropriations process. All year long, we heard nothing but talk about we want to get back to regular order. We're going to pass all of these 12 bills. Well, here we are in December, and we only have 3 bills that have been passed in terms of those overall appropriations. So the thinking is among several lawmakers, including Virginia Senator Tim Kaine, who I spoke to recently, is that maybe they can chip away. Maybe they can find some more and put them in an omnibus. They were talking about possibly doing an omnibus before they take their break, but that is simply not going to happen. So now they're looking at maybe January to potentially get another minibus, if you will, maybe get 4 or 5 of these major legislative packages through that way. But then we're staring down the barrels once again of January 30th, the shutdown showdown. And I've talked to some lawmakers about that, and they said, yep, it's going to be here before we know it. So they're hoping at least to get some goodwill back in the appropriations process as they chip away, as I said, related to these other measures. On the other side, I will say that the House Speaker, Mike Johnson, was very happy to make the point recently that they will not have the overall huge omnibus that, as you know, they often have right before Christmas or right during the holidays where they have to get everything done. This has been something that the Republicans have been really pushing back on. They don't want one of those big deals, and they're not going to get it because everything got pushed into 2026.
Well, it sounds like some lawmakers might be getting coal in their Christmas stockings.
I think there will be a lot of coal in Christmas stockings this year.
Mitchell, one of the other topics that comes to mind when you mention regular order is congressional oversight hearings. And there was a move towards oversight, especially regarding the boat strikes over the last week or so. What are you seeing there?
Well, I think it's an interesting tale of two cities, if you will, or tale of two chambers. On the House side, you've got a lot of review that has been taking place within the House Armed Services Committee, but the chairman, Mike Rogers, essentially said he is satisfied with what he has seen related to the video of that so-called two-tap strike. And then on the other side, on the Senate side, Roger Wicker, the Republican chair of the Senate Armed Services Committee, says, well, I want to see a little bit more. I want to get all the lawmakers on the committee to actually see the whole video. So it's interesting to see that little mini divide within the Republican Party. And then, of course, you have Democrats who are really calling for a lot more oversight, saying they have to look into this more. And, of course, that was exacerbated even more by the seizure of the tanker related to Venezuela. So there is a move, I think, among lawmakers to reassert some of the powers of the legislative branch, but we'll have to see how much that moves forward.
Well, the judicial branch got involved last week as well. There was a Supreme Court hearing on Monday about whether or not Trump's firing of an FTC commissioner was constitutional. And that has a lot of impact potentially for independent agencies. Any response there?
Yeah, there's a lot of concern about it because it seems like, at least particularly on the Democratic side, they feel that all of these independent panels are just slowly being taken away by various executive orders, and in this case, in the Supreme Court order decision. And there is a feeling that if this is allowed to continue, there really won't be any more independent panels, that it will go back essentially to the spoil system that used to take place many years ago, and they tried to wipe away all of this so that the politics didn't get involved with all these panels and commissions and committees. And that's why there is so much at stake to jump to the midterm elections, because right now there really isn't going to be much oversight related to this on the Republican side. They feel like the president has the power. He is going to do what he wants. But if the House flips and goes to the Democrats, then I think you're going to see a lot more oversight on issues just like this one, on issues like the one you spoke of related to the boat strikes. So that could really have a profound impact on what happens with Congress moving forward.
Well, it doesn't sound like we'll get much of a break over the holiday season. There's much to watch here as we go forward.
Lots of busy things happening here.
Mitchell Miller is Capitol Hill correspondent for WTOP. Thanks so much for joining me.
You bet.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts. Over the past year, there's been a major uptick in the government's use of the False Claims Act to take companies to task for cybersecurity violations. The Trump administration has announced 6 separate False Claims Act settlements, and enforcement has been especially aggressive for companies who do business with the Defense Department. Sarah McLean is a former assistant director of the fraud section in the Justice Department's commercial litigation branch. She talked with Federal News Network's Jason Miller about the enforcement trend.
There was in May 2021 an executive order directing basically all government agencies to get their arms around cybersecurity, do what they could on this issue. At the Justice Department, there was that launched a 360 review of cyber matters and all sorts of different efforts within the Justice Department. But one of them was that using the False Claims Act in this way. The False Claims Act is, I don't know if your listeners know, it requires it provides for treble damages and penalties for knowing false claims to the government. So it can be used and has been used for a lot of different requirements that come along with government funding. And so, I mean, in the Civil War, that was sawdust, instead of flour, lame mules. This was a new version of that sort of construct. That when somebody is providing the government something that is supposed to have cybersecurity and doesn't have what it should have, the False Claims Act can be used in this way. And really, I think the motivation was largely to improve cybersecurity, and also to just generally in the country to protect sensitive information, personal information, national security information, to ensure a level playing field so that you didn't have some folks who were meeting the requirements and others who were not, to ensure that incidents were being reported to the extent the False Claims Act could be used around that particular issue, because the thought was that that would enable the government to respond to cybersecurity problems, and that still is really the impetus now behind the more recent enforcement in the last few months.
When we talk about cybersecurity and False Claims Act, it's mostly around contracting, the use of, for instance, hey, NIST 853 is required, FISMA is required. Now we're getting into the cybersecurity maturity model certification over at DoD. Those are the types of things you all were looking at. Hey, did they say they met this requirement? We have evidence, or we were able to prove that they didn't actually meet it, and that's the connection. Maybe just go one step further to give us what you all were generally looking at, and was it a lot of that kind of provisions in contracting, but also the regulations and laws set up by Congress?
Yeah, exactly that. Provisions in contracting, regulations and laws set up by Congress. And a lot of the matters that have been announced, and by the way, about half of the resolutions that have been announced have been since January in the current administration, about and half before then. So it's been a very significant push recently. The matters that have been announced, a lot of them involve Department of Defense cybersecurity requirements, which are contractual, and they're regulatory. Regulations are incorporated into contracts that are signed. But the biggest other category is sensitive personal information, and again, oftentimes that's also contractual requirements. But particular agencies have been putting out more and more agencies, I guess, have been putting out more and more robust cybersecurity requirements, and all of those, can be the basis for one of these suits. But it's been what's been announced publicly has been a lot of DoD cases, and then a lot of other sort of odds and ends type contract cases where there was some sort of cybersecurity commitment that a qui tam relator, we can talk about that a little if you want, or the government alleged was knowingly not met.
This also has been a really big impetus to get contractors to come forward and kind of raise their hand to say, hey, we think we have a mistake. We want to mea culpa it, my second Latin phrase of the day. And that maybe will lessen the penalties. Have you started to see that too, or more companies are saying, hey, we messed up and we're sorry, versus trying to fight the no, we didn't do anything wrong, all is well, go away, hopefully you'll stop pursuing us?
Yes, definitely a lot of that. And DOJ has policies of giving credit in False Claims Act settlements for self-disclosure, cooperation, and remediation, and that is definitely something that is that's available, and that companies have been definitely taking advantage of in this space. And it's been, highly touted in the press releases that DOJ has put out. That this is available, because it's I think DOJ understands that there's more focus on cybersecurity than there used to be, and so there are companies that maybe didn't attend to this as much as they now wish they had in the past, who discover that they've got some kind of a problem and want to fix it and fix it going forward, but then also figure out how do I make it right and in the past, and how do I avoid a whistleblower coming forward, a would-be whistleblower coming forward and filing one of these qui tams, throw around our Latin language. That is a way that private citizens can file a complaint under the False Claims Act and get up to 30% of the government recovery if there is one, and the attorney's fees paid for their private sector counsel. So it's a huge, incentive for folks to come forward. You don't actually have to have a lot of information in order to qualify for the reward. But in the cyberspace, what we have seen is a lot of people who do have a lot of information coming forward, and cybersecurity professionals within companies, in particular, who come forward and say, "Hey, I said that the company shouldn't do this, and nobody listened to me, and it happened anyway," and file one of these suits. So I think a lot of companies have decided that, so there's a lot that goes into the consideration, but that it would be worthwhile to come forward on their own and get the credit that's available.
Let's talk a little bit about the work. I mean, how big is the cyber fraud unit? How many people focus on it? Or give me some of the inside of what happens in the Justice Department. Someone help me understand what you guys do every day, for lack of a better word.
Right. Not me, guys. What my former colleagues do. But
yes. What you used to do, right?
What I used to do, yes. So there's no separate cyber fraud unit in the Justice Department. There is a section of the Justice Department, the Civil Fraud section, that is sort of the mothership for False Claims Act cases. And that's about 130 lawyers or so right now. They work with the U.S. attorney's offices, and there are U.S. attorney's offices everywhere in the country, in every judicial district. And in every one of those offices, there are people who do this affirmative civil litigation, False Claims Act work, basically. And so the group in Washington that I was with is sort of the mothership for the effort, teams up with partners at the U.S. attorney's offices, and also teams up with the agencies, really critically. And there's a ton of cyber expertise, of course, in the government. As you know, you have people on your program, who do this day in, day out. Those people are available to the Justice Department to do these cases. And those are essentially the clients of the Justice Department in doing these cases and are behind the scenes guiding it. So there's, certainly the DOJ lawyers who are generalists had to learn the area, but had a ton of resources to draw on.
That's Sarah McLean, a former assistant director of the fraud section in the Justice Department's commercial litigation branch. To watch her full conversation with Jason Miller, check out Federal News Network's Risk and Compliance Exchange at federalnewsnetwork.com. The Federal Drive with Terry Gerton is produced by Eric White and Michelle Sandiford. Our web editors are Daisy Thornton and Stephanie Wright. For the latest updates, stay with federalnewsnetwork.com or follow us on Facebook, YouTube, and LinkedIn. I'm Terry Gerton. Thanks for listening.